Tantor Audio, a division of Recorded Books, presents The U.S. Supreme Court, a very short introduction by Linda Greenhouse, narrated by Dina Pearlman. Chapter 1, Origins. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may, from time to time, ordain and establish. With those words, the opening sentence of the Constitution's Article 3, the document's framers announced the birth of an institution then unknown to the world, a national court with the authority to decide cases arising under the country's Constitution and laws. Precisely what that authority would mean in practice, what the Supreme Court's role would be with respect to the two elected branches of the new government, was far from clear when the Constitution was drafted in 1787. That role remains disputed even today, when Supreme Court nominees are routinely asked by members of the Senate Judiciary Committee to disavow all interest in using the court's authority in a manner that might be described as judicial activism. This book is not intended primarily as a work of history. Its aim is to enable readers to understand how the Supreme Court of the United States operates today. But while detailed knowledge of the court's history is not required for that purpose, acquaintance with the court's origins helps appreciate the extent to which the Supreme Court that we know today has been the author of its own history. From the beginning, it has filled in the blanks of Article 3 by defining its own power. In the process, the court has defied Alexander Hamilton's prediction in Federalist No. 78, one of the 85 essays in the Federalist Papers written to rally public support for the Constitution's ratification, that lacking influence over either the sword or the purse, and possessing neither force nor will but merely judgment, the judiciary would prove to be the least dangerous branch. That process of self-definition continues today. The Articles of Confederation that the new United States ratified in 1781 provided neither a national judicial system nor an executive branch. There was a single national court, the Court of Appeals in cases of capture, with jurisdiction limited to disputes over captured ships. The Congress also had the power to establish special courts to resolve boundary disputes between states. Such a court had only sat once. Every state had its own system of courts, as the states do today. Citizens of the new nation had feared that a federal court system with general jurisdiction would threaten the sovereignty of the loosely confederated states. But to the delegates who assembled in Philadelphia in 1787 to revise the national charter, the absence of a national judicial system was one of the decentralized government's more obvious failings. The Constitutional Convention quickly agreed to the proposal of Governor Edmund Randolph of Virginia for a national government of 3 branches: legislative, executive, and judicial. Randolph's resolution that a national judiciary be established passed unanimously, debating and defining the powers of Congress in Article 1 and of the President in Article 2 consumed much of the delegates' attention and energy. Central provisions of Article 3 were the product of compromise and, in its fewer than 500 words, the article left important questions unresolved. Lacking agreement on a role for lower courts, for example, the delegates simply left it to Congress to decide how to structure them. The number of justices remained unspecified. Article 3 itself makes no reference to the office of Chief Justice, to whom the Constitution in Article 1 assigns only one specific duty, that of presiding over a Senate trial in a presidential impeachment. The convention debated at length over how the members of the Supreme Court should be selected, eventually settling on nomination by the President and confirmation by the Senate. By providing that federal judges shall hold their offices during good behavior, the delegates intended to protect judicial independence. But independence to do what, exactly? The delegates were aware that the Supreme Courts of several states were exercising the power of judicial review, invalidating legislative acts that, in the judge's view, violated provisions of the state's constitution. The Massachusetts Supreme Judicial Court, interpreting the Massachusetts Constitution of 1780, had invoked this power to declare slavery unconstitutional within the Commonwealth. Courts in Virginia, North Carolina, New Jersey, New York, and Rhode Island had also exercised judicial review, sometimes generating public controversy during the pre-Constitution period. Although the delegates appear to have assumed that the federal courts would exercise some form of judicial review over federal and state laws, Article 3 says nothing explicit on the subject. It states in broad terms that the federal court's judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties. It then goes on to list specific types of disputes over which the federal courts may exercise jurisdiction. Cases between states, cases between a state and citizens of another state, or between citizens of different states. Controversies to which the United States shall be a party, admiralty and maritime disputes, cases involving ambassadors and other foreign diplomats, and cases between a state or its citizens and the government or residents of a foreign state. For the Supreme Court specifically, Article 3 makes a distinction between original and appellate jurisdiction. Between the Supreme Court as a court of first resort for cases involving states or foreign diplomats, and the court as the recipient of appeals from lower courts in all other cases. Given the initial absence of lower courts, this distinction must have seemed quite arcane to readers of the judiciary article. It would shortly prove highly significant. Once the Constitution was ratified, Congress quickly turned to the task of setting up a court system within the Article 3 framework. The Judiciary Act of 1789, often called the First Judiciary Act, established 2 tiers of lower courts, 13 district courts that followed state lines, each with its own district judge, and 3 circuit courts for the Eastern, Middle, and Southern circuits. But the Judiciary Act did not provide for judges to staff the circuit courts. Instead, the circuits would be staffed during their 2 annual sittings by 2 Supreme Court justices and 1 district judge. This system required the justices to ride circuit, an onerous duty under primitive conditions of interstate transportation, and one that early justices keenly resented. Hannah Cushing, the wife of Justice William Cushing, referred to herself and her husband as traveling machines. Despite the justices' frequent complaints, however, this system lasted in somewhat modified form for more than a century, until Congress established fully staffed circuit courts, known today as U.S. Courts of Appeals, of which there are currently 13 in the Everts Act of 1891. The first Supreme Court, consisting of 5 associate justices and Chief Justice John Jay, a prominent New York lawyer from a distinguished family and a co-author of the Federalist Papers, began its work of self-definition almost immediately. 3 of the associate justices, John Rutledge of South Carolina, James Wilson of Pennsylvania, and John Blair, Jr. of Virginia, had been delegates to the Constitutional Convention. All were acutely aware of the court's place in the Constitution's design of separated powers. President George Washington later appointed 2 more Constitutional Convention veterans to the court, William Patterson of New Jersey and Oliver Ellsworth of Connecticut. One early turning point came in 1793, when Secretary of State Thomas Jefferson sent the Supreme Court a letter on behalf of President Washington requesting help in resolving questions of interpretation that had arisen under the 1778 treaty between France and the United States. The letter posed 29 specific questions. Judges of the state courts then commonly offered, as several still do, advisory opinions of the sort the president sought. But Chief Justice Jay and the associate justices viewed the request as falling outside the jurisdiction of the federal courts. In a letter to the president, the court responded, "The lines of separation drawn by the Constitution between the three departments of the government, there being in certain respects checks upon each other, and our being justices of a court in the last resort, are considerations which afford strong arguments against the propriety of our extrajudicially deciding the questions alluded to." This early rejection of an advisory role established a lasting principle, that the federal courts have the constitutional power to decide only those questions that arise in the context of disputes between opposing parties. The principle is easier to state than to apply, and the court has spent the subsequent 2 centuries elaborating on it. Even today, the contours of what is often referred to as the Article III jurisdiction of the federal courts remain contested. The important points here are simply these: that questions concerning the federal court's jurisdiction are anchored deeply in the nation's constitutional origins, and that the Supreme Court itself has provided the answers. The Supreme Court met for the first time on February 2, 1790 in New York City, the country's first capital. The court's meeting place was the Merchants' Exchange, sometimes referred to as the Royal Exchange building in Lower Manhattan, the first of several locations that served as a home for the Supreme Court, until the justices got their own building on Capitol Hill in 1935. After a year in New York, the court moved to Philadelphia, sitting first in the State House and then in the city's newly constructed City Hall, where the justices shared space with the mayor's court. After 9 years in Philadelphia, the court moved along with the rest of the national government to the new capital in Washington, D.C. in 1800. There, the court operated for the next 135 years from the Capitol building. That the President and Congress were able to move into their own homes by 1800, while the Supreme Court lacked its own real estate until nearly the middle of the 20th century, certainly suggests that the court, and the branch that it was to head, began life in something less than equal partnership with the other 2 branches. It would be up to the court itself to establish parity, something it achieved by giving itself dominion over the Constitution. In the beginning, the prospect seemed distant that the court would matter much at all. During its first 2 terms, February and August 1790, it had almost nothing to do. A year after its first session, the court finally received its first case, but the case settled before argument. 6 months later, in August 1791, the court received a second case, an appeal in a commercial dispute. The justices heard arguments, but then declared that a procedural irregularity in the appeal barred them from proceeding to a decision. Not until 1792 did the Supreme Court begin issuing opinions. In the early years, the justices worked hardest in their capacity as judges of the circuit courts, which had growing dockets due to their original jurisdiction over major federal crimes. It was in the circuit courts that the justices fleshed out some important principles of federal law and jurisdiction. One such instance came in 1792 in Hayburn's case. A new law, the Invalid Pensions Act, directed the circuit courts to act as pension boards and determine the pension claims of injured Revolutionary War veterans. The justices, as circuit judges, refused to exercise this new grant of jurisdiction. The problem was that any determination by the court that a veteran was entitled to a pension would be subject to review by the Secretary of War. In the justices' view, this added layer of executive branch review would turn the judicial determination into a non-judicial act. Justices sitting on each of the 3 circuits wrote separately to President Washington, explaining why they could not carry out the assigned duty. Such revision and control we deemed radically inconsistent with the independence of that judicial power which is vested in the courts. Justices James Wilson and John Blair, sitting on the Middle Circuit, explained in their letter. The Attorney General appealed to the Supreme Court, which heard arguments, but never issued a decision, because Congress revised the offending statute in the meantime. Was Hayburn's case, then, the first instance of the Supreme Court declaring an act of Congress unconstitutional? Not formally, but the dispute received wide attention and could have left little doubt in the public's mind that these justices would be zealous guardians of the jurisdictional boundaries that they understood the Constitution to have drawn. The next year, the court decided what is generally viewed as the major case of the early years. The decision, Chisholm v. Georgia, 1793, provoked an immediate backlash in the form of the first constitutional amendment to be ratified after the 10 amendments of the Bill of Rights. The case was a suit by a merchant in South Carolina against the state of Georgia for a Revolutionary War debt. The plaintiff sued directly in the Supreme Court under the provision of Article 3 that gave the court jurisdiction over suits between a state and a citizen of a different state. The court rejected Georgia's argument that as a sovereign state it was immune from suit without its consent. When Georgia refused to appear, the court entered a default judgment against it. The 5 justices in the majority, there was one dissent, each wrote a separate opinion, as was the custom. The opinions constituted a decision that was highly nationalist in tone. As to the purposes of the Union, therefore, Georgia is not a sovereign state, wrote Justice Wilson. Not surprisingly, the states were alarmed by this development, and a constitutional amendment to overrule the decision was introduced 2 days later. In 1798, the 11th Amendment received final ratification, providing that the jurisdiction of the federal courts shall not be construed to extend to cases brought by citizens of one state against another state. Despite that seemingly conclusive language, the scope of state immunity from suit was far from settled, and remains a contested question even today. Chief Justice Jay, who had run unsuccessfully for governor of New York while serving on the court, was elected governor in 1795 and resigned his office. A New York newspaper approvingly described the Chief Justice's election as governor as a promotion. Washington nominated John Rutledge of South Carolina, who had previously been confirmed to a position as an associate judge, but had resigned without ever taking his seat, in order to become Chief Justice of the South Carolina Court of Common Pleas. This time, Rutledge agreed to serve and accepted a recess appointment, but the Senate refused to confirm him. Because Rutledge did serve in the position of Chief Justice from August 12th until December 15th, 1795, he is counted as the country's second Chief Justice. Washington next nominated a sitting Associate Justice, William Cushing, whom the Senate promptly confirmed. But he declined to take his seat on the ground of poor health. The president's next nomination of Oliver Ellsworth of Connecticut was successful. He took his seat as the third Chief Justice in March 1796 and served until resigning in ill health on December 15, 1800. President John Adams then offered John Jay his old job back, but Jay, who by then had served 2 terms as New York's governor, declined, observing that he was perfectly convinced that the federal judicial system was fundamentally defective and could never acquire the public confidence and respect which, as the last resort of the justice of the nation, it should possess. This was the inauspicious background for the nomination by John Adams of John Marshall, his Secretary of State, to be the nation's 4th Chief Justice. Marshall, a Virginian and combat veteran of the Revolutionary War, was 45 years old, until this day the youngest person ever to assume the office. The next youngest was John G. Roberts, Jr., who became Chief Justice in 2005 at the age of 50. He was a national figure, having helped lead the effort in Virginia to ratify the Constitution, and later having undertaken an important diplomatic mission to France. He was the oldest of 15 children, a fact that may help explain his natural leadership qualities. Not infrequently, Marshall is mistakenly referred to as the first Chief Justice. The mistake is understandable. Taking his seat in February 1801, he served for more than 34 years, until his death on July 6, 1835. He left the court a transformed institution, no longer the stepsister of the other two branches. To the dismay of Thomas Jefferson, to whom Marshall administered the presidential oath of office on March 4, 1801, the Marshall Court embraced a strongly nationalist vision of the country and a willingness to harness the Constitution and the court's own authority as its primary interpreter in the service of that vision. Marbury v. Madison. The Marshall Court's best-known case and one of the most famous in Supreme Court history was decided early in the Chief Justice's tenure on February 24, 1803. It grew out of the tense and messy transition of power from the Adams Federalists to the Jeffersonian Republicans after the election of 1800. The Federalist-populated courts were a particular target of the victorious Republicans, especially after the outgoing Federalist Congress created 42 new judicial positions for President Adams to fill during his waning weeks in office. A Maryland tax collector, William Marbury, had received one of these midnight appointments as a Justice of the Peace for the District of Columbia. The Senate confirmed Marbury's appointment along with dozens of others. But in order to take office, the newly confirmed judicial officers needed to receive the actual commission, a piece of paper that Marbury had not received by the time the Adams administration left office. President Jefferson's Secretary of State, James Madison, refused to deliver the commission. Marbury, who had been active in Federalist political circles, filed suit directly in the Supreme Court. He sought a writ of mandamus, a judicial order commanding the delivery of his commission. It seemed a readily available remedy, because Congress, in the Judiciary Act of 1789, had explicitly provided that citizens could go directly to the Supreme Court to seek a writ of mandamus against a federal official. As a legal matter, then, the case seemed straightforward enough. But it was also highly political, and it placed the authority of the Supreme Court on the line. Madison was seen as likely to defy a direct order to give Marbury his commission. How could the Supreme Court uphold the rule of law without provoking a confrontation with the executive branch that could leave the court permanently weakened? Marshall's solution was to assert the court's power without directly exercising it. His opinion for a unanimous court, speaking in one voice in the new Marshall style, rather than through a series of separate concurring opinions, as in the past, held that Marbury was due his commission, but that the court could not order it delivered. That was because the grant of original jurisdiction to the Supreme Court in Article 3 did not include writs of mandamus. Section 13 of the Judiciary Act, in which Congress gave the court jurisdiction to decide original mandamus actions like Marbury's, was therefore unconstitutional, and no mandamus could be issued. The decision gave the court a measure of insulation at a time of political turmoil. Without an order, the Jefferson administration had nothing to complain about. The decision's significance, of course, lay in the court's assertion of authority to review the constitutionality of acts of Congress. It is emphatically the province and duty of the Judicial Department to say what the law is, Marshall declared, a line that the court has invoked throughout its history, down to the present. In the guise of modestly disclaiming authority to act, the court had assumed for itself great power. The full extent of that power was not immediately apparent. In fact, only 6 days later, with Chief Justice Marshall not participating, the court avoided a possible constitutional confrontation. Voting 5-0 in Stewart v. Laird, 1803, the justices upheld Congress's repeal of the Judiciary Act of 1801, a move some historians see as reflecting the court's unwillingness to test the full dimensions of the power it had just claimed for itself. More than half a century would pass before the Supreme Court again declared an act of Congress unconstitutional. That was the Dred Scott decision of 1857, Scott v. Sandford, invalidating the Missouri Compromise and holding that Congress lacked authority to abolish slavery in the territories. That notorious decision, a step on the road to the Civil War, was perhaps not the best advertisement for judicial review. But since then, the court has lost its early reticence. It has declared acts of Congress unconstitutional nearly 200 times. How the modern court exercises its great power, how cases reach the court, and how the justices proceed to select them and decide them, who the justices are and how they are chosen, are the subjects of the remainder of this book. Chapter 2. The Court at Work 1. A disappointed litigant's vow to take my case all the way to the Supreme Court is likely to prove an empty threat. An appeal on the way to the Supreme Court encounters many obstacles. Some derive from the Constitution itself. Article 3 limits the jurisdiction of the federal courts to deciding cases and controversies, although, as we shall learn, the meaning of those words is hardly self-evident. Another obstacle is inherent in the Supreme Court's place in the federal system. The court generally may not review a state Supreme Court's interpretation of a state's own constitution. For example, the court could not have reviewed the Massachusetts Supreme Judicial Court's decision in 2003 to grant same-sex couples the right to marry under state law, 12 years before the U.S. Supreme Court found the same right in the U.S. Constitution in Obergefell v. Hodges, because the state court based its decision on its interpretation of the Massachusetts Constitution, Goodridge v. Department of Public Health. State high court decisions that interpret the U.S. Constitution do fall within the Supreme Court's jurisdiction, however. Other obstacles to Supreme Court review stem from federal law. For example, Congress has set strict deadlines for filing Supreme Court appeals. Someone who has followed all the rules and whose case falls cleanly within the court's jurisdiction then encounters perhaps the most daunting obstacle of all, the justice's freedom to say no. Unlike most appellate courts, which must act on all properly presented appeals, the Supreme Court has nearly complete control over its docket. Year in and year out, the justices agree to decide only about 1% of the cases that reach them. The court hears appeals from the 13 federal appeals courts, the high courts of the 50 states, and occasionally from other courts, including the highest court in the military justice system, the U.S. Court of Appeals for the Armed Forces. A small category of cases, most notably appeals concerning voting rights and redistricting, reach the court directly from special federal district courts. During the 2021-22 term, 4,900 new petitions for review reached the court. Carrying over 897 petitions from the previous term, including 31 that the justices had already agreed to hear, but that had not yet been argued, the court granted an additional 74 cases and issued a total of 58 opinions. Several recent examples illustrate the types of cases the Supreme Court decides and how the justices approach the task of decision. While there is no typical Supreme Court case, there is a typical range of cases during a given term, with the cases that the court has chosen to review falling roughly evenly into two main categories. One category consists of cases of constitutional interpretation, usually involving a claim that a federal or state statute or...
Sample complete. Ready to continue?